Okay, that looks like the numbers trickling in have slowed, so we might get started. Hi everyone, thank you so much for joining us in this breakfast webinar, another one in the series of IPRIA IP Australia events. I'm coming to you from the unceded lands of the Wurundjeri people of the Kulin Nations, where I pay my respects to their elders, past, present, and emerging, and also to their warriors who are fighting to reclaim knowledge, language, and culture. I really love these IP Australia IPRIA seminars because we have such a great opportunity for cross-pollination of ideas from government and to government, from practitioners and industry and academics, and so on. So I hope everybody is doing okay in lockdown, and also that you like this format. This is the first time we've run a breakfast seminar. This is why I'll be drinking my ludicrously large smoothie during it. We chose this time because we are honoured to have Professor Joshua Gans as one of our speakers today, and there's a little bit of time difference there. But we might send a survey around and see what you think of this time as an alternative to our regular lunchtime events. So I'm going to jump right in now so that we can hear as much as we can from our panelists. The reason we are here is because Australia's federal court ruled at the end of July that an AI system could be named an inventor for the purpose of patent law, which overturned an earlier decision of IP Australia finding otherwise. Now that decision is going to be appealed to see whether it is in fact correct on the law. But what we're really interested in today is the much juicier normative question of whether the law should enable AI systems to be classified as inventors for patent. So we have a terrific panel of experts to talk this out. We have Professor Joshua Gans, Professor of Strategic Management and holder of the Jeffrey S. Skoll Chair of Technical Innovation and Entrepreneurship at the Rotman School of Management at the University of Toronto, with a cross-appointment in the Department of Economics. Joshua is also Chief Economist of the University of Toronto's Creative Destruction Lab. Before 2011, he was the Foundation Professor of Management, Information Economics at the Melbourne Business School, right here at the University of Melbourne, and before that at the School of Economics, UNSW. He holds a lot of very prestigious qualifications and used to once be in this chair working with IPRIA as well. We also have Professor Kimberlee Weatherall at the Law School at the University of Sydney, and a chief investigator on the ARC Centre of Excellence for Automated Decision-Making and Society. She specialises in issues at this intersection of law and technology, as well as intellectual property law. She's a fellow at the Gradient Institute and a research affiliate of the Humanising Machine Intelligence Group at the ANU. Kimberlee works with researchers in law, data science, and media studies on questions relating to AI ethics and legality, data and data governance. And we have our very own Professor Jeannie Paterson, a professor of law here at the Law School at the University of Melbourne, specialising in the contract, consumer protection, and consumer credit law fields, including the role of emerging technologies in these areas. She really focuses on regulatory design for consumer protection, concepts of fairness in law and legislation, and governance strategies for fair, safe, and reliable AI. Okay, so those are the experts that are going to be speaking today. We're going to be aiming for quite a freewheeling discussion and sort of centered around this question, this normative question of whether AI systems should be able to be inventors for the purpose of patent law. So we have, as is usual in this format, we have the Q&A available. Please do ask your questions if you've got any, and as this progresses, I will be sort of throwing them into the mix as well. All right, I'm gonna throw open to our panelists. Perhaps Kim, I can put you in the hot seat. Would you mind just very briefly explaining the Thaler case, and maybe kicking us off around that key question?
Thank you, Rebecca, and thank you for the invitation to be here. It's so great to be back at IPRIA and talking about this case, which I've been grumbling to all kinds of people about ever since it was decided. So good chance to have this chat. You asked me to briefly explain what this is about. We're talking, it's basically a case where the Patent Office has refused a patent. What was strange about this patent? Well, the patent filed with the Australian Patent Office and actually patent offices all over the world wasn't unusual so much for its invention, although if you look at the inventions, the drink container and the light to get attention, they're interesting. What was strange about this patent was that in the place where you would usually see the names of human beings as inventors, there was instead this word DARBUS. And DARBUS stands for the device for the autonomous bootstrapping of unified sentience. And it is in effect a couple of coupled artificial intelligences. So it's a machine. And when the patent got knocked back saying you need to identify an inventor, there's no inventor here, the inventor, Thaler, insisted, no, we have an inventor and the inventor is the artificial intelligence, and there's no reason why a patent shouldn't be granted to with that artificial intelligence named as the inventor. Now, there's no claim, just to be really clear, that the artificial intelligence is a legal entity or that it owns the patent. The claim rather is that Thaler owns the patent because he owns the artificial intelligence, but there's nothing wrong with saying AI can be an inventor under the Patent Act. Now, this case is part of a provocation, really, and it's a provocation that's been levelled at patent offices all over the world for this patent, in effect, and Thaler as inventor. It's designed as a test case, meant to force patent offices to confront what the proponents perceive as shortcomings of the current legal rules, and to get recognition for invention by artificial intelligence. Now, courts and, well, patent offices first, and then courts later all over the world have been turning down this patent. Justice Beech's decision a couple of months ago is one of the only ones, the only one, apart from another decision, I think, in South Africa on fairly procedural grounds, that said, no, full consideration, there's no reason under the Australian Patents Act that artificial intelligence can't be treated as an inventor. And so the Patent Office's refusal to consider the patent was knocked back. As Rebecca said, this case is now on appeal. So that's enough of an introduction. You're probably familiar with much of this. And I really like the way that Rebecca has framed this event. You know, I've been to other discussions of the case. This is the first one where I really feel like we can get into this. Really, does it make sense to treat artificial intelligence as an inventor? And I have lots of reasons why I think it doesn't make sense. But I'll start with this question about incentives, right? The big thread that you see running through a lot of the literature in this space, and the big thread that you see running through the case and the decision is, this is what the patent system is designed for. The patent system is designed to encourage innovation and technological innovation and provide incentives for that innovation. And if we don't grant patents for inventions invented by artificial intelligence, the system will fail to fulfill its basic underlying purposes. But we need to think more deeply about the way that patent law does that. There's no doubt that government intended for the patent system to cover new technologies and to provide incentives for innovation. But the legislation also envisages a certain mechanism for that incentive. The grant of the monopoly in the invention is the incentive for the creation of that invention. Now, Abbott and his friends are, when the Pete Thaler and his counsel are arguing that granting patents for the outputs of DARBUS is an incentive for investing in DARBUS and machines like it, in these creative machines. They're trying to get patents effectively as the incentive for the prior investment, not for the innovation named in the patent. And it can't be an incentive. These patents can't be an incentive for the actual invention listed in the patent because the machine doesn't need that incentive. It's more like saying, we will grant monopolies on the things that come out of the lab as an incentive for building the lab. And the patent incentive isn't designed for that. And the flawed design is obvious. It once you think about it, you know, the idea is you'll get patents for everything that comes out of this machine or everything that comes out of this lab. And as long as the lab or the machine keeps spitting out inventions, we'll keep renewing and creating these new monopolies. The patent incentive isn't designed for that. If we do want to incentivize the underlying lab investment, the investment in the AI, we'd be better off designing an instrument fit for that purpose. The other thing I just want to say is, you know, people sort of point to the objective of the Patent Act and say the objective is to encourage technological innovation, but nowhere in the objectives of the Act and nowhere in the design of the patent system is it said or argued or designed so that patents will be the only way we incentivise investment in innovation. We've got loads of other systems that are designed for this. We've got R&D investment incentives in the tax system, just as one example. So an argument that, oh, innovation will fall apart if we don't grant patents for this, just fundamentally misconceives the role of the patent as part of a suite of systems we have for incentives for innovation. I have so many more things I want to say, but I don't want to dominate the conversation. So I might see what Jeannie thinks of all of this.
Thanks so much, Kim. Well, I probably are going to leave the discussion about the Patent Act to the patent experts. I just wanted to talk actually about DABUS and the characterisation and treatment of this, and picking up on a point actually, Kim, that I've had a discussion I've had with you in another place. So the case, as mentioned, came out of some writings largely by Ryan Abbott. And Ryan Abbott's principal thesis is of AI neutrality. So we shouldn't discriminate in the law between AI behaviour and human behaviour. And that argument means that we should grant patents to, or we say that AI can be an inventor, and it means other things as well, that AI should be taxed and AI should be responsible when it's running an automated vehicle. So there's an assumption there that we can analogize human and AI behaviour. And for me, that's the really interesting point in the case, because it seems from my reading of the case that Justice Beach relied primarily on the characterisation of AI generally, and AI in specific form of DABUS, presented by Dr. Thaler and his lawyers. And there was very little contesting or unpacking of the description of that AI and what it meant. And so I'll just take a couple of minutes to describe both the description of DABUS and the characterisation of what that AI could do. So Justice Beach described DABUS as a self-organising cumulative result of algorithms collaboratively generating complexity. Now, that was actually key to Justice Beach's decision about that an AI could be an inventor, that DABUS could be an inventor, because for him, this AI is generating novel patterns of information rather than just associating patterns. Extrapolating from this, Justice Beach thought that DABUS was more than just a computational tool. It was autonomous, it was or at least semi-autonomous. And he talked about DABUS exercising choice. So it determined its own pathways, it's determined its own goals, it even selected its own data, and it selected the iterations of the neural networks that would be used to produce the output. Now, in any AI, a human sets up, chooses the data, configures the system, and in some ways dictates the outputs. So Justice Beach made a leap and said the human involvement is, if you like, too remote to be considered to be producing the outputs. For Beach, DABUS was in some way creating, and it was doing more than just processing information. Now, most computer scientists that I've spoken to would say that an AI finds patterns in data. It processes information. It does effectively what it's told. It may do so in ways that humans can't quite predict or understand, but it's just doing statistics effectively. And my query about the case is none of that was unpacked in the case. So we never had the debate about just whether this sort of anthropomorphic characterisation of AI is the one that we should be using. Over to you, Joshua.
There's a lot going on here in this. Let me see if I can set the mood first. I'd like to read you the lyrics of a song, and you're going to tell me something about it. There's a shifting in the way we produce knowledge, and the most valuable teacher may not be a professor at all. Some new technologies are changing the way we make decisions, and the rate of production is changing how we govern. So is this a new economy or an extension of the old? I don't think we can be sure unless we know how to collaborate. What is the purpose of knowledge if it is not to teach? Now, let me ask my fellow panelists if they recognize the author of that, those lyrics. No one? No one recognizes it? I mean, if you sang it, it would sound very much like Taylor Swift. But of course, it isn't Taylor Swift. What it is a professor by the name of Erik Brynjolfsson put into an engine called GPT-3 and asked it to write a song about the abstract of his paper in the style of Taylor Swift. And that is what I just read to you. Now, the question is, who wrote that song? Now, we're talking about patents here, not copyright, but this has come up in copyright before. Who should own the copyright as the writer of that song? Should it be GPT-3, the machine? Should it be Erik Brynjolfsson, who put the prompt into do so? The machine would never have produced it without that prompt. Should it be the people OpenAI who developed the machine? Or should it be any number of the sub-technologies that went into making that in the first place? Or should it be Taylor Swift? Because it was Taylor Swift's original song lyrics that were used to generate this whole thing. So you can see here, we get into a murky situation. Many inventions today are created by multiple entities and multiple things, which is, why elsewhere, and I only learned this just before this talk, elsewhere, the assignment of who the inventor is matters very much, because you are supposed to actually identify who it was who produced the invention, and not, for instance, add your significant other as a gift to give them inventing credits. And you wouldn't do that if you were co-authoring a paper or anything like that, add people who haven't contributed. So it's very much this invention function, which is of course distinct from the exclusionary rights and all of the other things you get from patents that do generate incentives. So it's a very murky area, these sorts of things. But we had a similar case to this recently in copyright, which was, there was a monkey. There's a man went out into the forest, into a jungle, took very expensive equipment and set them up, and then allowed a monkey to take pictures. And the monkey took a picture of a selfie, and that selfie went all over the internet. And then there was a court case. Who owned the picture? In copyright, it's the person who created it. If I used the camera, I would be the one who owned the picture. Well, the court decided, of course, that no one owned this picture. Not the monkey, not the person who supplied the cameras, which, when you're thinking from an incentive point of view, was in fact the right person to assign copyright in this particular matter. So we've had stuff like this. And now I read this judgment in that light, and basically what Justice Beach is saying is, if you've got a dog, I've got a dog, Dee. If I write a patent in Australia, I could name the dog as a inventor on that patent, and it'd be no problem with that. Because, she was sitting on my lap when I came up with my great thoughts, or whatever it was, inspired me. I looked at what she was doing, or who knows what. So that's why this gets to be a crazy issue. Now, there are several layers of this issue. Let me also comment on this. This is not the first time someone's tried to attribute something to artificial intelligence. One of the very first artificial intelligence was called logic theorist. It was developed by Herbert Simon, later on won the Turing Award and Nobel Prize for Economics, so no slouch at any of this. And this was 60 years ago. And they ran this logic engine to produce the theorems of the chapter 2 of Principia Mathematica logic text. And one of the proofs that it came up was so elegant, and no one had ever seen it before, they tried to get it published with Simon, his co-author, and logic theorists listed as authors. And the journal wouldn't have it. You can't do that. Now, again, that's the same issue. So this is not even very new, this entire thing of attribution. But in this particular case, what struck me reading it, and I've already said Jeannie has touched on this, is it was uncontested that we had an intelligence at work going on. It was uncontested. When we got a monkey taking a picture, we've got an intelligence at work. That we know. The only reason we don't assign ownership to a monkey is because we're mean to monkeys as a society. Okay? It's so we can legitimately, for instance, kill them without being charged with murder. But if you have artificial intelligence, you have to assign them some intelligence. And Jeannie hit it on the head. This is not artificial intelligence. All current artificial intelligence of this kind is just an advance in statistics. So basically, if I was developing something and I was using a favorite statistical program, Stata or R, and I ran some regressions and I came up with something surprising in them, and I said, well, now that leads to an invention. What this judgment is saying, I can add my statistical package as an inventor here. Now that strikes me as surely ludicrous. Should Thomas Edison be able to add his soldering iron to be an inventor of the light bulb? That's the level we're talking on here. Now, if you had introduced this case and said, get rid of this word artificial intelligence, it's the advance in statistics, and then we did a cut and replace on that whole judgment saying, should we allow a statistical package to be an inventor? You tell me if that judge would have come. I know Justice Beach. I would be very interested to see if he would come to the same conclusion, because at the moment we are saying he must come to the same conclusion because we don't have artificial intelligence. Now, in the future, we may have that. And we even admit that these statistical packages are an advance in the method of inventing. I ran a conference a few years ago. There's a book volume from it called The Economics of Artificial Intelligence, a Research Agenda, that anyone can get. If you read in there, there's a paper by Ian Coburn, a very famous patent testifying person, a previous visitor to IPRIA, Rebecca Henderson, and Scott Stern. And they basically said what we should be characterizing a lot of artificial intelligence advances these days is an advance in the method of inventing. Now, in no way or form, we've had previous advances in the method of inventing. The example they gave was the wind tunnel. The wind tunnel made huge advances in aircraft design. I've never, ever heard of anyone trying to get a wind tunnel patented. So I walk back at this and say, why didn't anyone ask what's going on here? And what's going on here when you visit the Thaler website is it was a marketing gimmick. And I cannot believe that a marketing gimmick was able to get up in a court. And I can only imagine, and this will be the controversial bit because I know who's in the audience, that that was a failure to put forward exactly what this case was about in this matter. And that was a statistical package. In the future, we may have a case about artificial intelligence and there might exist such a thing. We can then talk about that. But right now, we don't have it.
Okay, now lots to digest there. I might just come right back to Kim, because Kim, I know you had a few more points you wanted to make before we continue on. What is there in that other list of things that you wanted to get to that hasn't been covered yet, or do you want to respond to any of those provocations?
Look, I think this is terrific, and I love the points that Jeannie and Joshua are raising about what is the nature of this thing, and wouldn't it have been better if we could have just unpacked all of this and gone back to the basics of what is this? It's a tool. You know, it's a tool for making new inventions. And, you know, that is also the response to, I saw John Canning's comment in the Q&A, an AI is creative, a lab is not. It's not an instrument alone once independent. And I think Jeannie and Joshua have answered that very well. In fact, an AI is, you know, there's an assumption in that question, and it's the same assumption Justice Beach has made, which is that the AI involved here, or an AI that could be out there right now in the world, is in fact creating and creative. And the reality is, as Jeannie has pointed out, if you talk to computer scientists, and all the ones I've talked to and the data scientists, they'll say no, it's not. But, you know, the other points that go on here, you know, and the question that you posed at the start and the question that was posed as the title for today was, should we treat AI as an inventor in patent, an inventor in that sense, and even assuming that, you know, even making the assumption that AI could be creative, is creative, I would say that the patent system is not, in fact, designed to include AI as an inventor, and the whole way that we've interpreted and understood patent law doesn't fit this. So I do have a couple of other points that I wanted to make, and that is the other, you know, another thing that is wrong with Justice Beach's decision, and another thing that bothers me about the way that all these cases have been argued and run, is that it fails to see the patent system, in context, as I talked about before, as only one mechanism that we have in our legal and economic system for encouraging innovation. And secondly, it fails to see the patent system as a system, and as a system of interlocking parts, where we have concepts like invention and obviousness and inventive step. One of the really unattractive things about the argument being raised in the, as what Joshua has characterised as this marketing stunt, is very much this feeling of, we want to have our cake and eat it too. We want to say AI is the inventor and characterise them as the inventor, but we want everything else in the patent system to just remain as is, and everything else to remain the same. We want the standard of inventive step to remain the same and to remain judged by the inventiveness, or, you know, what a hypothetical skilled but uninventive researcher or research team would come up with. We want to keep a 20-year patent term because that's how the patent system is written at the moment. So we want to keep everything else the same, but just add in an entirely different way of creating or inventing in this, you know, alleged creative AI. And that is, yeah, go on.
Can I step in and ask you a hypothetical question on exactly that point?
Yeah.
This is a computer program, this AI.
Mm-hmm.
It's what you can do with computer programs. You can replicate them. Tell me what would happen to the following. I replicate this computer program. Same starting conditions. Okay, same starting conditions. No such thing as randomization. So I mean, when I mean same starting conditions, I mean it. Okay? And at the exact same time, we press return on the running of this program. And then at the exact same time, both produce this invention.
Mm-hmm.
What would have Justice Beach decided in that instance if machine A was listed as the inventor and somebody else who owned machine B was contesting it?
Well, as the patent system, of course, is run as a first person to the patent office system.
I'll make it even easier.
If you have two inventors,
invention popped out, it automatically led to a filing of a patent for that thing simultaneously received at the patent office. So I don't want to even, I'm not going to allow you off the hook that way. So the key point making is, you know, would this be something someone skilled in the arts would have come up with. And I've just duplicated it. So there is someone else skilled in the arts who did come up with it at exactly the same time. So how could you possibly, with a replicable program, clear that hurdle? That entire patent should be invalid if they're claiming this is the inventor, because the characteristics of the inventor is such that it would not be possible to clear the minimum inventive step.
So I don't know. I mean, you're taking me down into the weeds of patent law here, but the standard
That's
of
the idea.
Yeah, I know you're mean. The standard of the inventor, the standard of inventive step is not the same as, you know, the standard of invention. Well, let me take a step back. When we judge whether a patent has cleared the hurdle, we ask whether a hypothetical skilled researcher or research team in the art, so a hypothetical research team skilled in the art, would have effectively come up with the same invention. But we characterize them as uninventive. So what you're positing to me is actually two inventors. But all of this assumes that we have this kind of creative.
Well, I don't know. By definition, let me break it from my same time. Millisecond, one is millisecond ahead of the other and files first. But the evidence is that there existed another, actually, there existed another 100 who did the same thing. Let me tell you, if these were people and you got to the patent office and there were 100 other people with the exact same invention who invented it a minute earlier, you agree.
Then there would be serious questions about whether this cleared the hurdle.
I've just told you that the basic property of exactly this technology that was found to be an invention is that could have happened. In fact, it must have happened because they probably have a backup somewhere.
That actually wasn't the question they were addressing in the case. They weren't. No. There was other hurdles that had to go through. This was the case here was not looking at the question of the other questions that are necessary about inventiveness and uniqueness. It was simply looking at whether. I know.
But just bring the whole patent down. The patent should be invalid because it is not an invention.
But that's not the question that was being considered in the case. The case is considering something quite different.
A broader thing.
But can I respond? Which is, Joshua is raising a point that this patent should be invalid. But one thing that he is more generally raising is that this actually, assuming all these facts, this actually means that the patent system doesn't work. All of the interlocking parts don't work if you accept this argument. And so changing this one thing, which Justice Beach effectively does by reading inventor broadly, raises serious questions about how all of the other interlocking parts of the patent system work. And that is where you have to say that the approach to statutory interpretation is faulty. Because if you can't make the whole, if you can't make the whole system work, if pulling apart and changing this bit means that everything else really doesn't work very well, then no single court decision, no full federal court decision should be making that choice. What we should be doing is asking the legislative policy question of going back and saying, do we want to provide incentives in this kind of way for AI? And as soon as you ask that question, you go, well, that doesn't make sense because the AI is not incentivized by patent. If this is a different kind of inventive system, we want to do things differently. And can I make one more point, which is something else I wanted to come to? If you say we have to do this through the patent system, if you put AI into the patent system and say, we'll treat AI as inventors and this is how we will incentivize this kind of innovation, you are seriously stuffed. And one of the reasons is patent law and the shape of our patent law is determined by unchangeable treaties. Treaties that we cannot amend that dictate things like we have to have 20 years. We have to have patents for every area of innovation. We have to have patents for, new uses of known products, et cetera, et cetera. The shape of our patent system is dictated by treaty. If we put AI into the patent system, we have to give it all of the same kinds of protection, and you wouldn't design an incentive system like this for AI. I have no problem with having a discussion about how we incentivize innovation in this space or investment in AI, et cetera, but I'm saying take it out of the patent system because it's inflexible. End rant.
Terrific. I'm loving all of the rants. I did ask the panelists if they would rant, so I'm very grateful for that. Now, we are having some really, really interesting questions come up in the Q&A, and some of these have kind of been answered and sort of teased in as we go. I would sort of encourage everyone to have a look at those questions, but I'm just going to pick a few of them out at the moment. And Jeannie, you wanted to say something. There's been a bunch of observations about human brains, the nature of human brains, and then what are the differences here. Do you want to say something about that?
Yeah, so thanks, Rebecca. And it probably goes back to Joshua's point, because Joshua said that on, that it would be same if I had a dog on my lap and said the dog invented the dog was the inventor. I think that's not where Beach is actually getting to. I think Justice Beach is trying to engage in a more sophisticated argument, though it may arrive at the same place. This is that there is a philosophical question about the nature of human mind and the nature of what a computer can do and whether they can be analogized. So in the year 12 philosophy, they read an article by Searle, which is called Is the Human Mind a Computer? And it asks that interesting question that is coming up in the chat about, well, do humans think like computers and do computers think like people? And one of the problems that we arrive at, I think, when we start to talk about AI is that to us at the moment, it doesn't look like a mere tool. It doesn't look like a pencil. It doesn't look like a calculator. It doesn't look like a working dog. It looks like something different because it's extremely complex. And one of the things about neural networks is that we don't know how the connections are made. Neural networks process large amounts of data and find correlations in that data to produce outputs. And the distraction that happens there is that because the process is complicated and in some way unknowable, the answer seems to be, well, it's like a person or it's autonomous. And I think that the interesting question that I'll come back to, because I'm probably just a one-trick pony perhaps, is that complexity doesn't make the system autonomous. Complexity is just complex. And complexity doesn't make the system like a human brain. Human brains can do all sorts of things. They can recognize bad song lyrics. They can be ironic. They can recognize features of faces in all sorts of conditions. So complexity is not equal to what happens when we have the firing of neurons. Now, of course, in law, we can draw the line between what's an autonomous creator and what isn't at any point we like. But I think that it has to come from, unpacking these questions about precisely the impact of complexity and correlation and whether that actually is at any way at all analogizable to what humans do. And that's quite a complex, discussion and argument.
I think there's one sense in which that is off base and one sense in which that's completely on base. So let me try and explain. So I would agree with that, and it's coming through the Q&A. There's no bright line between machines and human cognitive abilities. Makes it a problem.
But that's not what I'm saying.
No, I know you know. I know. I would say actually all the things you listed as intelligence, by the way, are shared by my dog, but we could argue about that. That's a question of fact. However, the issue is that in this particular instance, with the current technology we had, the description of how this invention took place is completely incomplete and probably was misleading to the judge. And the reason is this, is that algorithm produced thousands of options. And who chose the one to patent? Who chose, aha, Eureka, I have now found something that is worthwhile. Well, I gather probably Mr. Thaler is the likely person who chose that thing. All current statistical packages, of which these are one, and I don't care that it's complex, and I don't care that there are people who run it who don't understand the results they get. By the way, which also applies to people running an Excel spreadsheet, okay? And that's just skill. Even in the most complicated AI systems, they know what's going on. I've been embedded in this for now a decade. One of the inventors of AI is just around the corner from where I'm sitting here at the moment. I've watched these develop. I know what it's like. 30 years ago, I sat in a course on genetic algorithms taught by the person who, in this site for this particular business, John Koza, who was doing the same thing there. We just have better computers now. That's all that's going on here. And so there's none of that's like new. People know this, and people can run their programs and not know what's coming out, or they can know what's coming out. So a question of fact in this case that was not put forward clearly to Justice Beach, or at least I couldn't see, was the description of what was done to invent this thing accurate? And I'm going to say, I just don't buy it. I just don't buy it, given there's so much of artificial intelligence, especially when it comes to creating new stuff. I've watched drug discovery, I've watched all that stuff. There is an art to it. You can't just run the machine, and you can't get something approved in the field unless you understand why it is working. You really can't, whether it be a building material or something else. You have to understand that. And so that has been one of the lessons. One of the lessons businesses are learning today is they can't just run these things and hope them to work. They actually have to understand them. So I come back and I dispute this and say, what is going on in fact in this case is not what was found by facts as the court did. The court found something that is completely out from current scientific knowledge if it was drawing those sorts of inferences. Now, there's a great discussion to be had is, what if we ever pass that threshold? What if we have an AI who can sit there and wake up one morning and say, well, I could invest this, but I choose not to, and actually exercises that choice. This AI had no choice. And I go back because all my references on legal cases come from Star Trek: The Next Generation. And there are a couple of legal cases in there, but I'm sure you show A Measure of a Man where they decided whether the android data was a property or not. And this comes, that's where we're going to get the interesting issues. But right now, there's no dispute. There's no dispute. And we also know the AI can do nothing without somebody skilled helping them, which is partly why my little experiment was not very fair.
Now, what's been really interesting in the chat, we can see a lot of people sort of starting to ask questions about sort of more about the nature of AI. And one of the questions from Warwick Rothney is, well, apart from that book that you mentioned, Joshua, what should we be reading to understand better what an AI is and does, so that we don't fall prey to the same sort of anthropomorphism bias?
That is obvious. You need to read this best-selling Prediction Machines by myself, Hagawal and Harvey Goldfarb.
Come on, Warwick,
but seriously, because that's what it was a book written for business people, so they could understand what are they really going to get from this current technology, what can they expect to do from it. And so this is an accessible version of that. Now, it doesn't touch on any of these interesting issues, but there are other ones. There's a great book by Brian Christensen called the Alignment Problem. There's all sorts of interesting books around. Sorry, Jeanine wants to advertise as well, which of course you should do so.
I was just saying it's probably good to read a book by a computer scientist. So Artificial Intelligence, A Modern Approach is sort of probably the go-to textbook that you can sit down and read.
Yeah, but even those are dealing with some special things that don't yet exist. And they get very concerned about AI safety and whether...
No, they don't. They're pretty good on actually what doesn't exist. I just think, I think they're pretty measured actually. The fourth edition's pretty clear on what doesn't exist and what
Oh,
does exist, Joshua. And yeah.
All right, we've got some, I'm going to jump in with some other, we've got so many great questions. I'm afraid we're not going to be able to get to many of them at all, but this one from Melissa Adams has really got me thinking. Do you think that one of the large motivators to having AIs recognized as inventors is to destabilize the patent system? So perhaps to flood an area with prior art that human inventors then have to overcome or amend around. Anyone have any thoughts on that?
Go on.
Look, certainly, it is not for me to look into the minds of Thaler, Ryan Abbott, or any of those people who are pushing this particular line of argument. On a charitable view, the whole thing is a provocation, right? It is a provocation to, as they say, force patent officers to confront this question. Of course, that's like fundamentally the wrong approach, because it's not patent officers that should be confronting this question. It's legislators, it's policymakers, it's us, right? Who should be confronting questions of, is the patent system still fit for purpose in the context of this kind of invention? And those are debates actually we need to be having regardless of whether you put the AI in the inventor slot or not. So there's fundamentally the wrong approach. If we do go down this line and we say, AI can be an inventor, and we invent, there are systems pretty close to what Joshua was describing where the AI effectively writes the specification, we click a few buttons and have it submit automatically and overwhelm patent officers. Can I imagine someone doing that for fun? Absolutely. Someone patented the wheel in Australia when the innovation patent system was created. So I can absolutely imagine people doing that. Whether that was part of the motivation of these people, don't know, don't care.
So another great question here has come out from Michael. So there's certainly no excitement from this panel about the prospect of allowing AI's systems to be inventors. So then thinking about the alternatives, he asks, given the importance of data to developers of AI systems and potential for those that control data to obtain a market advantage in AI applications, is the proper mechanism for incentivizing innovation in AI through regulating rights and access to data? Any more excitement for that?
No. I mean, even in this particular case here, they didn't use data, and there as I can tell. So, but no, that's not going to be an issue going on here. It was in my Taylor Swift example. That was a data issue, no doubt about that. But not here. I think look, did I? So can I ask a question again of Jeannie and Kim? Am I wrong to think that this case allows an animal to be an inventor, or a under 3-year-old to be an inventor? Am I wrong about that?
There's nothing in this decision that suggests that 3-year-olds and dogs can become inventors, I don't think.
Really? Because I thought, so the main thing that I thought was convinced about was this, was it is possible, if we don't allow an AI to be an inventor, it is possible that we will have no inventor at all. Okay? So if I took a 3-year-old, and I know that's really crazy, and they did something. Oh no. There's a parrot whose beak was broken and doesn't have the top part of their beak and just the bottom part. And the parrot did something that nobody's ever observed anybody ever do before, but collected a pebble and inserted it into their beak and uses it to preen themselves. Okay, that's actually an invention from the way we would think about it. No one had thought about doing that, and this parrot did think about it and was able to do it. If someone said, I want to patent a method for a device that parrots with broken beaks can use to preen themselves without us having to build another beak, and I wanted to patent that, surely I could list, I don't know what this bird's name is, as the inventor. And if I didn't list them as the inventor, would I not have an inventor? Which was the thing, I think, in my reading of it, that Justice Beach was quite persuaded of, that he was worried that if I didn't allow this, I wouldn't have one. And I see that, and alongside all the measures of intelligence and other things that he was sort of running around with, as allowing all manner of stuff, all manner of things to be inventors.
Can I just mention one comment that's come in, is that somebody saying that there's been a 3-year-old inventor in the UK who was actually given a patent at age 5. So,
yep.
Okay.
Right.
Let's so we can
focus on the parrot and the monkey.
let's move to the animals, because that's what really gets people energized, right?
What I don't understand is why we're so concerned that there might not be an inventor.
Yes, exactly.
Because that just means there might not be a patent.
Since you already told me just before this thing that the inventor part of the Australian law is literally nothing. It's literally has no factual basis required for it whatsoever in terms of people. I can no.
Joshua, let me qualify your understanding of the law here.
Okay.
The Raising the Bar Act did change the law. It used to be the case in Australia that if you failed to name the right inventors, your patent was void. Right. And that led to, patents being voided because someone's name had been left off. And Section 22, I think it's 22A. I'm saying that off the top of my head, but that was changed by the Raising the Bar.
AI lawyer would have known the answer to that, Kim.
I'm no Ryan Abbott, and I'm no David Chavin either. But that doesn't mean you don't need an invention. The whole rest of the Act is based on having an invention. So I don't think it means that, I don't think anything in this reasoning means that you don't have to have an inventor/invention for there to be a valid patent.
Well, I think this is the interesting thing that gets in this appeal part, because if the finding is that this was really an intelligent thing, and intelligent things are covered and can be inventors, that's a finding of fact. I don't agree with it, but it's a finding of fact. But if the reasoning was it was a residual argument, if we didn't allow this, there might not be an inventor. That's an interesting legal argument of interpretation of this Act, of everything you've said, which is going to be more interesting.
Well, yeah, I mean, what the courts, because this question, of course, has confronted the courts overseas, who have effectively said this is not a valid patent application. And you can have inventions without valid patent applications. You can have you can have things being created without us granting a monopoly in them under the patent system. So I don't understand this concern that there must if we have something that looks like an invention, there must be an inventor and we must be able to grant property in it. That's not how the system is designed to work.
So we've got, I have to say, the questions have completely gotten away from me this time because we've had such a fast-moving and interesting panel. Thank you, everyone, for asking the ones that we didn't manage to get to. But I think in the couple of minutes that we've got left, we possibly only have time for this one more. Let's see how it goes. But what then, all right, if it's not patent, and maybe it's not data rights, what then are the proper policy mechanisms for incentivizing innovation in AI?
I think the patent's pretty good for it. I think if you develop an AI and you are the person who's operating the AI, guiding it, tasking it, and you decide to be an inventor, and then the thing that the AI that has been produced out of that is the thing you patent and can exclude, then you have all the reason in the world to develop AIs that can produce those sorts of things, because they're helping you produce inventions. So I don't see any issue with the patent system being able to incentivize any of these sorts of things. I find that a completely spurious line you know, if they were putting forward that that's what they needed. I don't agree with it. And also, it was just who was listed the inventor anyway. When it comes to, you know, an AI actually owning the invention, that's going to be interesting.
Kim, what do you think?
I suppose in some ways the answer depends on what sort of invention system we're imagining. No, I'm going to leave that one because I think that's a question for economics and for policy discussion and for a combined policy and law discussion that I don't have time for in 3 minutes. Sorry.
Jeannie, do you want to say anything on this one? Perhaps just around some mechanisms that are already incentivizing innovation in AI, and that doesn't have to be specific to this.
I think there's lots of incentives for innovation in AI, and I think probably actually we need to pass more laws about the use of AI rather than incentivizing it. I'm actually also going to make a plug for, I'm a private lawyer. There's a great discussion in this case about how that resonates with the book that's been written by the other Gans. It's a great discussion in this case about how the patent comes to be in the hands of the human owner of the AI. And it's all about the progeny of animals and the fruit of trees. So if you're the owner of land and your tree has fruit, you own the fruit. And if you're the owner of an animal and it has a offspring, you're the owner of the offspring. And that's the analogy that's used for how Dr. Thaler gets the patent from Davis, which I think is a great bit of law, but once again comes back to this sort of living analogy of AI that runs through the case.
Terrific.
And if I'm going to plug a book, the other Gans has written a book on animal law.
Oh, I so wanted to have a go at that analogy too, because you talk
what
about,
did he
you know,
intend it to be? I haven't seen that one. He wrote his previous book was about using a Ouija board to be a jury. Oh, that's an interesting one. Could the Ouija board be the inventor of something?
There we go.
Cows. AIs are not cows. There are no cow developers putting together bits of cows from training data and existing algorithms. You don't have people with multiple potential ownership and licenses.
Oh, no.
Cows. It's a terrible analogy.
Kim, Elon Musk has implanted an AI interface in a monkey brain.
Well,
it's not really an AI interface. It's an electric chip that relaxes to a computer. I mean...
Oh, no, it reads the brain waves and provides...
No, it doesn't read the brain waves. It picks up one...
All right, so I think that we are about out of time. I want to thank the panelists very much, because I said I would really like an active, spirited, freewheeling conversation, and boy, have they given us that. Very much appreciate your time, and also the time of everybody who has come along today or who's going to watch the recorded version. And it sounds like there is a lot of interest in these issues, and we're going to be keeping talking about them for the next year or two while we iron this out. Thanks again, everybody. Have a great day.